Hello, we're back. And in this last video lecture, we're going to cover such things as medical identity theft, using PHI for marketing purposes, and other topics. Let's have a look. Okay, this next set of slides covers marketing with PHI. So what do we mean by marketing with PHI? Let's take a look at marketing. What's considered marketing is any communication about a product or service that encourages the recipient to purchase or use that product or service. And usually the general rule of thumb is using or sharing PHI for marketing needs a person's permission. In other words, a written authorization. And any payment or remuneration, as they say here, to the covered entity must be disclosed. So rather than go through all the minutia that's in this slide, let's talk about when authorization is not needed. It's not needed if the marketing happens face to face with an individual. So a patient is at said medical center, they're having a paid diabetes management class or something like that, and provider tells them face to face, that's not considered the something that requires an authorization. If it's about a small free gift, if it's a reminder about a prescription, as long as the payment's only for the cost of sending the reminder, and if it's for treatment or health care operations and no one is being paid for sending that message, an authorization is not needed. So that kind of begs the question, when do we need an authorization? And we need one if it doesn't fit any of that category. So in other words, it's considered marketing unless it's something that is exceptionally carved out, such as public health, research, treatment, payment, and operations, right? Then it's not considered marketing. Any fundraising. So fundraising, we can use PHI for fundraising, but without permission, but we have to tell people how to opt out. If the fundraising targets people based on their diagnosis, we need permission, right? So we can use it, right? We can use PHI for fundraising and use people's name, address, dates of service, right? But we have to tell people how to get off the mailing list, right? If a fundraising targets people based on their diagnosis, give to Crohn's Colitis Foundation or give to the American Cancer Society, then we need to get their permission. So, what does all of this mean? What all of this means, and to summarize, is we need to always inform people how their PHI is going to be used. We always need to give people a way to opt out of marketing or fundraising messages. And never confuse treatment, payment, or operations with marketing. We can't ever base treatment or payment on whether somebody agrees to marketing or fundraising messages. We also have administrative rules under the HIPAA privacy rule. And these administrative requirements, I should have said instead of administrative rules, these administrative requirements include that we need to have a designated privacy officer. And increasingly, a number of health information professionals are becoming privacy officers. We need to have policies and procedures about handling PHI. We need to provide workforce training, particularly about patient privacy, PHI, and what have you. We need to have penalties for noncompliance. We need to have a strategy for mitigation, data safeguards, and if people report things, retaliation, what have you, is strictly prohibited. And then we need to keep documents and record retention related to this. We need to have records of who's attended this training and so on. And again, there are different tiers of penalties and this what kind of a penalty you get for violations of the HIPAA privacy rule depends on whether it was a knowing violation or unknowing, whether it was due to reasonable cause or not, whether it was willful neglect or not, whether it was corrected or uncorrected willful neglect. And in addition to the feds, their state attorney generals, they may issue civil actions based on alleged HIPAA violations. The Department of Health and Human Services audits in terms of these types of things. So audits are actually done, and individuals can be prosecuted for HIPAA violations in addition to the penalties and sanctions that are brought against the healthcare organization. There can also be penalties assessed on the business associates, which is what the BAs are. The process of giving PHI to individuals outside outside the organization, excuse me, is based on the fact of whether they are deemed authorized to receive it and review it. And to do this, as you'll learn about in the legal ethics class, is we'll enter a request in the disclosure database. We'll determine whether it's a valid authorization or not. We'll identify the patient's identity, and then we process the request. And you'll learn more about this also in the legal class. There's certain quality measures for release of information. These include the turnaround times and the accuracy. So not only do we want to get these things turned around within the legal mandated time frame, but we want to make sure we're releasing the right information on the right patient. And again, a term that you see come up a lot of times when talking about release information is authorizations, whether they're valid or not. Under the HIPAA privacy rule, to have a valid authorization, it has to contain not only the patient's name and signature, but the description of the information that's going to be disclosed, the name and an entity authorized to request it, the name and entity to whom the information is that the release is directed to. And then the description of the purpose for the disclosure, the expiration date, the statement of the right to revoke this, and then the prohibition on conditioning treatment, payment, or benefits on signing the authorization. And typically there is a redisclosure statement along with, of course, the signature and date. And these things need to be validated for each authorization. Another thing about authorizations, only those patients who are legally competent can authorize a disclosure. Minors, for instance, unless they're emancipated minors, cannot release information, and adults with permanent or temporary disabilities. Certain highly sensitive diagnoses, such as mental health, substance abuse treatment, HIV, AIDS, and genetic information, are typically given more protection under most state law. Now we're getting into medical identity theft, and this could involve a patient, this could involve a provider, or a payer. But whether it involves a patient, provider, or a payer, it's basically using somebody else's identity to either obtain medical services or goods, somebody using someone else's health plan card when they don't have insurance, right? That's defrauding the payer, or goods, right? I'm a patient, I make an insurance claim, I'm trying to claim something back from a payer, right? And it can involve the creation of wrong information, the alteration of existing information, or intertwining a victim and the perpetrator's information. We see this a lot before we started requiring ID in California. People would borrow a relative's Blue Cross, Anthem, or Kaiser card and then get treatment, right? So this can result in not only fraud and abuse, but deadly medical treatment or potentially lack of treatment that a patient could have gotten. Medical identity theft can either be internal, which is much more common, than external, right? If it's external, they usually the patient has clicked on a link, done something, filled out a form unwittingly, and what have you. Internal is certainly more prevalent. Under the Fair and Accurate Credit Transactions Act, the FACTA rule, we have red flag rule to identify, detect, and respond to identity theft indicators. These are based on 5 categories. They could be alerts or notifications from a consumer reporting agency like Experian or what have you. Somebody applies for a loan in somebody else's name, claiming to be a physician provider. This could be suspicious documents, suspicious identifying information, unusual or suspicious activity, or notices from customers, identity thefts, or law enforcement or others about possible identity theft related to an account. In terms of compliance and auditing, with compliance, we need to conform to applicable laws and ethical practices. We need to do the right thing. Your State Health Information Management Association is a great place to learn the differences in state laws regarding privacy and release of information. We like to make this blanket assumption sometimes that all the laws are similar since HIPAA, and that's definitely not the case. Even the differences between California and Oregon. A culture of compliance is critical. People have to believe that compliance is the right thing to do. We need to follow all laws that are applicable to an organization. So in other words, if an organization is a covered entity, they need to follow all those HIPAA privacy rules. With auditing reveals any inconsistent or non-compliant practices that can be corrected. And this protects the organization against financial, reputational, and legal well-being and prevents any non-compliance with state, local, and federal law. Auditing is carried out to ensure that we are compliant with all applicable laws and engaging in ethical practices regarding the use of PHI. And that's all I have for you. The one thing I would like to stress to keep in mind with PHI, we always need to inform patients about how their PHI is to be used. With marketing, we always need to allow people to opt out of marketing campaigns. And again, we can never base treatment or threaten to withhold treatment payment based on whether somebody agrees to opt in for marketing or not. I hope you find this useful. Please reach out if you have any questions about this material. Bye now.